Well, hello, boys and girls, and welcome to our last discussion session together. And I think it's fitting that our last chapter should be consumer protection, a scintillating, didactic, and provocative subject, right? And I've got here my little aid, so if anybody is not fired up over this subject, we're going to provide some positive reinforcement, okay? Well, anyway, welcome to our very last session together. So hopefully you have found our journey interesting. I always look forward to your email comments, so don't be afraid to email me any suggestions for improvement and any questions that you may have about your grades that you have accumulated along the way. Well, why should we be interested in consumer protection when we're talking about commercial law and ethics? Well, I think Abraham Lincoln had it right when he said, that the government should only do for the people what the people cannot do for themselves. I think that is an excellent observation on his part in terms of government regulation. And so as we're going to see, we're going to be looking at the most important laws in the consumer protection business. And I think we need to answer, first off, why do you think the public needs protecting? And so we're going to take a look at some unlawful types of sales practices. And I think, we've got to begin with a philosophy, right? A sales philosophy. Should our sales philosophy be based on a laissez-faire, caveat emptor, hey, let the buyer beware type of business foundation? Do you think let the buyer beware should always be the way the public faces business? And that the public only does business with business at its own danger? Really? Well, I think as we have seen in our historic review over this semester, that, business law has changed. Commercial law and ethics have certainly evolved from the 1800s to the 1900s and now into the 21st century. And the idea that, hey, everybody's on their own, and hey, if you're hurt by a business enterprise, well, that's just too bad, so sad, dear dad. It's your problem. Well, I think we have ethically evolved to the point that no, there are some actions by business that, people cannot remedy themselves. And so they need government regulation in order to protect them and to avoid exploitation and being taken advantage of. So the first big consumer protection law that was enacted was the Federal Trade Commission Act that very specifically prohibits unfair and deceptive advertising. It created the Federal Trade Commission as an independent governmental agency. It's not within the executive branch, nor is it under Congress. It is a separate, standalone federal agency. Now, the Federal Trade Commission Act empowers the agency through the use of administrative hearings to issue cease and desist orders to businesses, to require affirmative disclosures that have to be made, as we're going to see, to consumers. They can order corrective advertising or other, types of action that may be occurring. So let's take, for example, one of my favorites. I remember seeing this late one night on television and thought, wow, if this isn't an example of deceptive advertising, I don't know what is. The advertisement was for a solar dryer. And all you had to do was dial into this 800 number and give them your credit card number, and for $50, they would rush you this solar dryer. Well, when you received this box and opened it up, anticipating your solar dryer, whatever one of those looks like, guess what the buyer received? A clothesline for $50. So what do you think? Do you think that's what deceptive advertising looks like? Well, what could that individual consumer do with respect to that seller? Probably not a whole much, not a whole lot. And so as a result, we've got the Federal Trade Commission Act, and the Federal Trade Commission is a federal agency that regulates deceptive advertising. Or how about, as we're going to see here today also, an unsubstantiated claim. This product will take 10 pounds off you the first week in a weight reduction program and 5 pounds every week thereafter. Well, that's quite a claim, right? But what happens if it turns out not to be true? That in fact, what you buy in the mail or what comes in the mail are just sugar pills. We'd say, well, wait a minute, that's deceptive, that's fraud, right? But what power do you have to police that? Not much, right? Well, in comes, of course, the Federal Trade Commission. Now, what is bait and switch? Have you ever run into bait and switch? Bait and switch is the situation of where a product is advertised and you come in to purchase the product at the sales price only to discover, oh no, we just ran out of that product. We don't have any more left. But we've got another one that's just as good but costs a little bit more. You ever run into one of those? Called bait and switch. Well, I think we could all agree that involves some degree of deception. And there are state laws as well as federal law that prohibits that type of sales behavior. So what do you think most big box stores do when they advertise a sale item and they run out of it? What do you think they do? Well, most of the big box stores give redeemable chits so that when the item does come back in to stock, you can procure it at the sales price. And that's what most of your big box stores do when they run out of sales items. That obviously avoids potential problems with bait and switch. Now, you probably have heard from your Wall Street Journal of the Consumer Financial Protection Bureau that actually Senator Elizabeth Warren helped sponsor and get the Congress to enact. And some years ago during the Obama administration, the CFPB came into being, and its purpose is to regulate consumer financial products and services, including mortgages, credit cards, and of course, checking accounts. So it put the responsibility for regulating these under this one agency. But there are still other agencies, like the Comptroller of the Currency, that does perform similar, and some people have argued legitimately duplicative regulation. So how does the Consumer Financial Protection Bureau work? Well, you have the ability to go online and file a complaint. What the Bureau does is it sends your complaint to the offending company that has 15 days to respond to you, and then has an additional 60 days to resolve the issues. Now, what's important is the CFPB is obviously tracking this communication. And of course, once the 60 days expire, if the business has not gotten back with you to resolve your particular issue, then that obviously triggers CFPB further investigation and involvement. How about the Telephone Consumer Protection Act of 1991 that bans unsolicited automated dialing or pre-recorded solicitations? We've all been victimized by that, right? And there's actually a remuneration that you can receive by turning in an offender who engages in an unsolicited automated dial sales system. Telemarketing and the Consumer Fraud Abuse Prevention Act directs the Federal Trade Commission to establish some regulations here regarding telemarketers. And so telemarketers are required to make, when they make a sales pitch, to inform the listener that it in fact is a sales pitch and to identify the name of the seller and the product. And you cannot call anybody who is on the not call registry that you can sign up for online. They cannot use pre-recorded calls to cell phones or residential landlines without your permission. So let's take a look at an interesting case that I thought you might find interesting. The Federal Trade Commission versus the Direct Marketing Concepts Company. So we got the Direct Marketing Concepts Company that broadcasts an infomercial. Get a load of this. For Coral Calcium that features a spokesman by the name of Robert Barefoot. Now, Barefoot asserts that in the ad, that virtually all diseases are caused by a condition called acidosis. Can you believe that? That most diseases are caused by acidosis? Sounds a little misleading to start, right? Oh, it gets better. So Barefoot asserts that calcium derived from an Okinawan coral cures these diseases by rendering the body more alkaline. Well, are you convinced yet that you ought to buy this product? Well, Barefoot claims that, there are unspecified articles in the Journal of the American Medical Association and the New England Journal of Medicine that calcium supplements reverse cancer. Wow, does that sound like an attractive item you want to buy? Well, the Federal Trade Commission filed suit alleging that the infomercials were deceptive advertising. What do you think? Sound deceptive to you? The trial court granted summary judgment on the basis of the facts. And of course, the Direct Marketing Concepts Company appealed. And the legal issue presented on appeal is, hey, were the infomercials misleading as a matter of law? So what's the basic rule here, obviously involving the Federal Trade Commission Act? Advertising is deceptive if the FTC, one, can demonstrate that evidence would in fact establish such a claim in the relevant scientific community, and two, compare the advertiser's evidence to that required by the scientific community. Well, guess what? We don't have any scientific evidence presented by Direct Marketing Concepts. While the FTC produced 4 expert declarations that demonstrated that if such claims could be substantiated by a double-blind, placebo-controlled human study, then, hey, then that could be a legitimate claim. But guess what? The defendants didn't produce any evidence to raise even the tiniest of fact issues. So the summary judgment in favor of the FTC was affirmed. So yeah, you've got to pay attention and report those that are engaging in deceptive advertising, because there are lots of miscreants out there, and you've seen them, who engage in this type of behavior and are in need of policing. Have you ever run across the Fair Packaging and Labeling Act? This requires labels on consumer goods to identify not only the product, what it is that's in the box or the can, but who the manufacturer is, who the processor or packager is, and then also has to set out, so what's the weight, what's the quantity, serving portion. These are all required disclosure items that must be on the package or the can. So have you ever stopped to take a look at all this information contained on packages? You should. How about door-to-door sales deals? Have you ever had a door-to-door salesperson besides the Girl Scout cookie sellers? Well, they used to be pretty common. They're not as common anymore, but there used to be encyclopedias that used to get sold that way from door-to-door sales. So why is this important to be aware of? Because there are specific laws that require what's called a 72-hour or 3-day cooling off period. So even though you agree to buy the encyclopedia for a gazillion dollars over a period of X amount of months, you have a 3-day cooling off period, which means for no reason at all, you terminate the contract. And you're not liable. You don't need a reason. You just have changed your mind. You've got 72 hours from the time you sign the contract during which you can rescind it for no reason at all. Now, the Federal Trade Commission specifically prohibits unfair practices. So what is an unfair business sales practice? What do they look like? Well, it's a practice that causes substantial harm and consumer injury. So let's go back to my solar dryer, in which after you paid your $50 on your credit card, you received a clothesline. I think we could probably agree that's what substantial harm looks like. And the harm outweighs any countervailing benefit. You all have seen the sex enhancement commercials on television. So what do you think? Is there scientific evidence to back up the alleged sex enhancement? But that very likely, if there isn't scientific evidence supporting the claim, the business advertising claim, then that would be an FTC prohibited practice. The consumer could not reasonably avoid the injury because the consumer doesn't know that the product, in fact, is fraudulent and doesn't do what it claims to do. I mean, consumers don't go around conducting scientific experiments on goods that are being advertised, right? Any practice that violates public policy can also be prohibited by the FTC. So you see that happen, especially around Christmas time. The FTC issues a variety of regulations prohibiting certain types of products that may be dangerous to children, for example, that may get stuck in their throats and whatnot. Now, the Consumer Finance Protection Bureau that was enacted during the Obama administration can take action by itself against anyone who engages in abusive acts, which are defined as taking unreasonable advantage of or a lack of understanding on the part of a consumer of the material risks, costs, or conditions of a product or service. So that's where deceptive advertising frequently comes into play. So let's talk about money. How many of you are familiar with the TILA Act, the Truth in Lending Act? Federal law. This federal law requires creditors to disclose the following in consumer transactions involving $53,500 or less, or real estate loans on principal dwellings in any amount enforced by the Federal Reserve Board through its infamous Regulation Z. So let's get specific. What does TILA require? It says, well, you have to disclose to a consumer in writing the cash price and down payment, the trade-in allowance, the finance charge APR, annual percentage rate, charges that are not included in the finance charge, such as a credit check, the total dollar amount financed. So, for example, as I already mentioned, a credit check, but other types of costs all have to be laid out. So, for example, when you purchase real estate, there's a long breakdown, a financial list of all the expenses that are required by TILA to be disclosed to the buyer or purchaser. This applies to consumer leases as well, but doesn't involve consumers or real estate, or doesn't involve leases between consumers or real estate leases. And there are civil and criminal penalties. Now, note, just like I mentioned before about the door-to-door 72-hour sales rule, note there is also a 72-hour rescission right after closing. So what do we mean? So when you are purchasing real estate, you will have an event during which you will sign the purchase documents, sign the mortgage, and this type of thing. But you've got 3 days to change your mind at no cost to you. And so you need no reason at all to change your mind. But if you suddenly decide, well, after all, I don't want to buy this house, well, then you may, or purchase this car, you can rescind. That is, get your money back and cancel the contract with no penalties whatsoever. Now, if a seller doesn't disclose in writing these TILA provisions that I've just mentioned, then the buyer has up to 3 years to rescind that purchase contract and get all their money back. Another federal law we want to bring to your attention is the Fair Credit Reporting Act, which permits consumers to obtain from creditors and sellers the name and substance of any information that is contained in a credit file that they have on the consumer, sources of that information, names of recipients to whom that credit report has been sent during the past 6 months, and they can compel the agency to investigate any alleged errors. And if there's no correction, the consumer can file a statement not to exceed 100 words that must be filed with the credit record. Now, I have run into this before in former spouse cases. That is, where you have a former spouse who doesn't change her name, and she continues to use your name and runs up charges, and that obviously can create confusion, and especially if the bills aren't paid, then this boomerangs back on the former spouse. And so you can place a 100-word statement, affidavit, if you will, in your credit file that the credit agency is required to send out, that simply says you were divorced on X date and you're no longer responsible in accordance with your divorce decree for debts incurred by your former spouse. That's a good way to try and clean your record up and to maintain it once a divorce has occurred. How about the Fair Debt Collection Practices Act? Ever heard of that? Well, this is addressed towards collection agencies and creditors and prohibits them from harassing, abusing, or threatening creditors, from using false or misleading representations or unfair or threatening actions. Creditors cannot contact a debtor before 8 in the morning or after 9 o'clock at night. So this is all in the statute. And if you want to stop them from bothering you, you can provide a written notice that you want no further contact from them, and they're required by this law to stop. And it is, yes, the FTC that enforces this. Let me give you an example of an egregious case I had. I had a young Army enlisted soldier who came to see me with respect to this collection agency that was calling her at all hours of the day and night. And she was behind on her credit card fees, but I explained to her, look, if you want to turn them off, here, let's prepare a letter. I'll do it for you right now and sign it and send it in, and that should turn them off. Well, she came back to see me because she had received a telephone call from a collection agency that said they knew where her 2 children went to elementary school. And if she wanted them to stay safe, she better pay off her credit card charges within the next 48 hours. Well, that certainly is what an unfair or threatening action looks like. And clearly, this young soldier, she was pretty upset. So I was trying to figure out how we are going to deal with this when she opened up her a satchel she was carrying with her and took out a telephone recording machine. And she had recorded the conversation by the collection agent. Holy Toledo, ka-ching, ka-ching, ka-ching. Oh, I about jumped out of my skin. I was so excited. This was wonderful. So we filed an action against the collection agency and also the company that the collection agency represented. And as I suspected, they denied ever making such a threat. We loved it. So I put my client on the stand, and after she finished testifying, I brought out the recording machine and pressed the play button for the judge. We did a judge alone trial. And holy Toledo, the collection agency's lawyer was doing handsprings, wanting a recess. And of course, I wanted no recess. I wanted to march on with this. Clearly, you know, they had lied under oath, and the judge looked at that the same way my client and I looked at it, and he hammered them pretty good indeed. And so, yes, keep track of creditors contacting you, and if possible, even record any telephone conversations. Well, we've got the Cruiser versus the Bank of America, case. Cruiser thought his credit card had been destroyed, but someone had certainly come up with it and used it to make a $20 withdrawal in December, which the Cruisers didn't notice on their bank statement because they didn't check their bank statement. So the following July, someone withdrew over $9,000, which the Cruisers did discover in September. Now, the bank refused to refund the money because the Cruisers didn't bring this problem to their attention in a timely manner. So the Cruisers sued, and the trial court granted the bank's motion for summary judgment. What's our legal issue? Did the Cruisers fail to report the unauthorized withdrawal in December? Did that prevent them from recovering the money that was paid erroneously in July and August? Well, what's the rule? The rule of law is the unauthorized December withdrawal of $20, if it had been noticed and reported, would have given the bank the opportunity to prevent the July and August withdrawals. In other words, to stop payment on the credit card. So while Mrs. Cruz had the responsibility to review the bank's monthly statements, she neglected to do so. Even though Mrs. Cruz, who normally reviewed the bank statements, was ill in December, there was nothing that prevented her husband from doing so. And so they got stuck with the unauthorized use of their credit card. So what's the moral of the story? You should be checking your monthly credit card and bank statements to make sure nobody is using them in an unauthorized fashion. So let's talk about the Fair Credit Billing Act now. So if a consumer has been has complained about a bill and writes to the credit card company within 60 days of the receipt of the bill, the company is required to acknowledge receipt of the complaint within 30 days, and then within 2 billing cycles must investigate the complaint and respond. Now, where do we see this most often? Is when you have disputes with merchants, right? So when you've got a dispute between a consumer and a merchant, The credit card company cannot bill the consumer if there's a good faith attempt to resolve the dispute. The dispute involves more than $50, and you've got the merchant in the same state as the consumer or within 100 miles of the consumer. Now, clearly there is a burden on the consumer to notify the credit card company within 30 days that there is a problem. Okay? What's our Broxton King versus LaSalle Bank case? Well, here we've got this consumer who closed her account on August 31st, right? But after paying an overdraft fee, but she had set up with the bank normal account payments to the YMCA, $28 dues payment that was to be made monthly. The bank not only made that payment, but the bank on October 1st paid the YMCA again. So Broxton King sues on her own, and pro se means on her own without the aid of an attorney, to avoid liability. What's the question? Did the bank violate the Electronic Transfers Fund Act? Now, what does that federal law require? It provides that a consumer may stop pre-authorized payments up to 3 days prior to the transaction. All right, let's look at this case. The plaintiff clearly did not close her account 3 days before the scheduled monthly payment in September, right? And so she's liable for that one. However, with respect to the October transfer, the plaintiff is not liable because she closed her account a month earlier. And so while she loses on the September 1 transfer, she wins on the October transfer. So what's our takeaway here? Do not ignore state consumer safety and credit protection acts as well. So states have laws, consumer protection acts, that complement our federal laws, and so both apply. Well, boys and girls, I hope this information has been helpful to you. If there's anything I can do for you, you know I am but a email away. I wish you well. It's been fun to spend this journey with you this semester, and I hope in the area of commercial law and ethics, you've learned a lot, because that was the point of the exercise, right? Stay well and do well. Bye-bye.